Welcome to another episode of my 2 Cents Zambian Case Law podcast with me, your host, George Chintankwa Malipilo. The citation for today's case is Lindiwe.K.Chinyanta versus Doreen.C.Tembo, Supreme Court Judgment No. 28 of 2007. The case at hand seeks to solve the issue of who gets the right to be appointed as an administrator of an estate where there is no will. So this is about intestacy succession. Secondly, does the spouse have the right to be consulted or informed about any decision with regard to the appointment of an administrator of an estate? The brief facts of this case are as follows. Lindiwe.K.Chinyanta lost her husband on the 13th of February 2016. The husband left no will, meaning he did not provide for how his estate will be run by a personal representative, and as such, the law took its course. Therefore, there needed to be the appointment of administrator or administrator. As a result of this, whole left without no instructions, Doreen.Tembo, who was Lindiwe's sister-in-law, making Doreen.Tembo the sister to the deceased, decided to apply for letters of administration to the High Court of the Republic of Zambia so that she could manage the estate of the deceased person with her other brothers on behalf of the deceased. Now, Lindiwe was, of course, unhappy with the decision that was taken. Her argument was that she was the widower, and as a result, she had the priority eligibility to be appointed. In her mind, she was the one that was supposed to be appointed as the administrator in accordance with the law. She was also unhappy with the decision that she was not consulted or informed about the decision that was made. As a result of these events, Lindiwe decided to take a matter to the High Court of Zambia, arguing to say she had the priority eligibility to be appointed as administrator of her late husband's estate. Or in the alternative, her other argument was that she could be appointed joint administrator with any of the deceased's relatives. In short, Lindiwe's claim was the fact that she was the one that was supposed to be appointed as administrator. Now, the decision of the High Court was simple. They say that Lindiwe did not provide any evidence as to why the letters of administration that were granted to Doreen.Tembo and Doreen's other sisters. The court said there was no evidence, meaning that Lindiwe did not show why those letters of administration should be revoked in accordance with Section 29 of the Intestacy Succession Act. And as a result, her action was unsuccessful. Lindiwe, not deterred by the judgment, decided to take her appeal before the Supreme Court of Zambia. Lindiwe's argument did not change, and it was still the same argument. She was arguing that being the surviving spouse of the deceased's estate, she had the prior eligibility of being appointed as administrator over the deceased's siblings or relatives, and that she was never consulted about the whole appointment issue, and that she ought to have been consulted and informed about the appointment of administrators of the deceased's estate. The Supreme Court, having heard both arguments, came to the conclusion that the issue for determination here was whether the wife had priority interest in being appointed administrator over the deceased's relatives, and also whether under the law she was supposed to be consulted and informed over the said appointment of Doreen.Tembo and the deceased's other siblings to manage the estate of the deceased. In coming to their conclusion, the Supreme Court looked at Section 15 and Section 16 of the Intestacy Succession Act. In coming to their conclusion, they said what had to be considered was whether you had sufficient interest. And the term sufficient interest to them was the fact that a sibling, a child, a stranger, or even the wife could be seen as next of kin. So these are the people that can apply for letters of administration to manage the deceased's estate. They then came to the conclusion that applying those facts in Lindiwe's situation to this case at hand, there is nothing under the law to suggest that the surviving spouse has any prior eligibility to be appointed as the administrator of the estate of the deceased person. So meaning anyone who qualifies within the realm of Section 15 or Section 16 has the right to make the letters of administration and nobody has a prior interest. They also went on to conclude that under the Intestacy Succession Act, there is no obligation to consult the deceased's wife with regard to the appointment of an administrator. However, the court did throw a lifeline to say, if you, the surviving spouse, are unhappy with the appointments or you are objecting to those appointments, you can actually challenge those appointments in the High Court with the aim of revoking those letters of administration. But the revoking must come with evidence. You must show why those letters of administration must be revoked, and this must be done in accordance with Section 29 of the Intestacy Succession Act. The Supreme Court came to the conclusion that they could not side with Lindiwe based on what I've just stated, and she lost the case. Now, my 2 cents talking points on the issue are the issue of the prior eligibility hierarchy. Under the law and according to the according to the Supreme Court, their argument was that there is no prior eligibility or hierarchy when it comes to the appointment of an administrator. They are saying in order for you to be appointed as an administrator, you must show that you have sufficient interest in accordance with Section 15. So you can be the siblings of the deceased, the surviving spouse, even the creditor. If you are owed any money, you can make the application and the court will grant that application. Now, this goes against what a lot of scholars have gone on to say, that the Supreme Court did not consider Section 5 of the Intestacy Succession Act. Under that provision, it gives a columns as to how the property or the estate ought to be distributed. Now, the first person who gets a percentage is the surviving spouse, which is 20%. So the argument has always been actually the wife or the surviving spouse, has a priority interest. However, it must be noted that under the Constitution of the Republic of Zambia, it is very clear that the judgment of the Supreme Courts bind them, and also under the aspect of the binding precedents, similar cases are to be dealt with in the same manner. So if we had a case of this nature as to the priority interest or the hierarchy of appointment of an administrator, the case of Lindiwe.K.Chinyanta versus Doreen.C.Tembo would have to apply. The second issue was the aspect that there is no need for you to consult or inform the surviving spouse about the appointment of an administrator. So long you have sufficient interest and have applied, and this is in accordance with Section 15, you can actually be the administrator of the estate. However, the appointment of an administrator can still be challenged by those who object that appointment, and you can take your evidence to show why, and this has to be done in accordance with Section 29 of the Intestacy Succession Act, and you need to bring enough evidence. Furthermore, this also shows us that in our society, an administrator is legally appointed by the courts of the Republic of Zambia in the event that the deceased dies without leaving a will, basically telling us how his estate should be undertaken. That the will, without the will, you then have to go to court, be the administrator, not only manage the estate, distribute that estate, but you need to have letters of administration to do so. Therefore, if you do not have any letters of administration that have been obtained from the court, you are seen to be an intermeddler, and you can actually be arrested, or you can actually be reported to the office of the Administrator General. So that has been our case for today. Thank you for tuning in, and I hope you learned one or two things. I've been your host, George Chintankwa Malipilo. Thank you for tuning into the podcast, and I will see you next time.